No. Evan Meenan has his hand up, and we'll hear from him, and then Senator White had a question or comment.
Thank you very much. And again, just for the record, it's Evan Meenan from the Department of State's Attorneys. I just wanted to take a minute very briefly and respond to Matt Valerio's testimony, because it concerned me that maybe some folks were misconstruing my testimony and thinking that the department was advocating for some type of change to the self-defense standard as it existed before Act 27, which is not true. As I stated, we support S-184 even in its current form. It was not the intent to try and change the self-defense standard. We think S-184 helps to clarify that Act 27 was not supposed to change that standard, as reflected in the letter that Senator Sears mentioned. And as I mentioned, if the committee wants to recommend that the archaic list of relationships in subsection 1 be replaced with the just and necessary defense of a person's own life or the life of another person, the department would support that as well. Thank you.
Okay. All right. Senator White.
So before the suggestion came up about removing that, my suggestion was going to be that we should just add the language about the common law that you and Judge Zone, I believe it was, that talked about, and pass it. But I don't have strong feelings about removing that language if it doesn't do anything harmful.
No, I think we, thank you. I think, Eric, I think what I'm hearing from everyone is that it would be desirable to first consider striking whether or not we strike the crimes is a question for the committee, but adding a section that makes clear we're not impacting common law.
Yep, that makes sense. I've heard that as well from the committee and the witnesses, and I see the language in the aggravated assault statute, I think will fit in perfectly. So just, you'd say something like this section shall not be construed to limit or infringe upon defenses granted common law. That seems to be exactly the concept the committee is looking for.
Yeah, and I think since one has been an attempt to make clear, and it's been in law forever. I'm not sure I want to change that from the way it is in the bill. It's two whether we want to, I believe, whether we could put in a period right after in the forceful or violent suppression of a crime, instead of listing all those different crimes. So if it had to be so as I understand it, if you did that, put the period there, you're saying the crime needs to be forceful and it needs to be violent. And rather than describing what crimes they might be. Is that what I heard from the witnesses?
That was what I heard from the witnesses.
So it would read, if the person reasonably believed that the person or any other person was an imminent peril, and that it was necessary to repel that peril with deadly force in the forceful or violent suppression of a person. Stop right there, in the violent suppression of a crime.
I'd also like to push
No,
Dick
but-
for if I could make a plug for the archaic list in subsection 1. I look at that list as back in the days when, frankly, a man had control over his family. And I would just push for the elimination of that archaic list.
Do any of the witnesses have a problem with that, or any of the committee members?
I'd like to
Joe
take.
suggest?
If I may, Evan Meenan from the Department of State's Attorneys, I don't know that I was following that correctly, so perhaps this is more of a question, but if to was changed to in the forceful or violent suppression of a crime, I don't, since the word, because of the word suppression, I'm not sure that's the same thing as saying a crime being committed with force or violence. It's
Right,
more about
that's-
force or
yeah.
Right.
Yeah, you're right. Thank you. That's what I intended. Good pickup. Question now is, should we drop the names in the names?
Yeah.
Well, before we get to that, Senator Sears, I just want to follow up on what Evan was saying, what you were just mentioning about your intent. So now I'm not sure I'm following what you're suggesting for 2. Are you saying that you want to rewrite that so that the forceful or violent suppression, it would say necessary to repel the peril with deadly force in the forceful or violent suppression of a person attempting to commit a violent crime or to commit any crime?
Violent, or a violent crime.
Oh, that needs
So
work.
that,
You know what?
I think we're running afoul of the keep it simple standard.
Yeah,
Yeah. Maybe it's fine the way it is.
again, I would suggest
Because if you
again,
refer to common law, then you're covering everything else.
that's right, exactly.
So I don't think we need to change 2. The only question is, do you change 1? I guess you would just change that to unjust and necessary defense of a person's own life or the life of another.
Yep. I'd be interested to hear from Judge Zone whether he thinks there's any problem doing that.
Well, what I'm gonna do is ask Eric to redraft the bill, the strike all, send it out to everybody that's here, and receive comments next. I think we have some time built in next Friday, Peggy, if I'm not mistaken.
Next Friday, hold on, let me just look. We have S-265 from 9 to 10:45, and then we have Judge Novotny. So it
Wait a
depends
minute.
on that.
265
265 is the criminal threatening.
bill, but we're just gonna hear. We could do it.
Oh, I can't hear you. Sorry. Go
We
ahead.
could do it at 10:30.
10:30, okay.
Put on this one at 10:30, if Eric's available.
Yeah, that's fine with me. Thank you.
Okay.
So
sounds
we
good.
can, criminal threatening. I only have 2 witnesses, and there may be some others who want to testify at a future. But I just had Jim Condos and TJ Donovan. Anybody else who should be on that list for
Yep.
criminal threatening?
Yep, that's it.
Probably, oh, I know who. It would be the state's attorney in Washington County, and I never pronounced his last name right.
Rory
Yes.
Tebow.
You want me to get him
Thank you.
too? Rory T.
Yeah, we'll just stick to those 3 witnesses for Friday. It's a complex issue, and so well,
The Secretary of State asked for Chris Winters as well to be added.
that's fine.
Yeah, I figured.
He's like, I don't think condos can go anywhere. Okay, so is everybody okay with that? And everybody who's here will, who's here on S-26, S-184 will get a copy of the redraft from Eric, as well as the committee. The redraft can be posted, and then we if people aren't able to be here next Friday and you have any comments on it, you can certainly send them to Eric. Sounds like we're coming to some kind of resolution here.
Great. Thanks, Senator Steers. I'll send it out and everyone can take a look.
Thanks for working on that.
Okay,
Mr.
thank
Chair.
you. What's that?
Thanks for working on that. My conscience has been bothering me since I let this slip by last time.
Oh, certainly want your conscience cleared, Senator.
I don't know if that'll actually clear his whole conscience, but
Only around this.
Piecemeal.
By the way, did everybody hear the sad news today? Meatloaf died.
yeah.
What?
Meatloaf died at age 75. The singer.
Like a bat out of hell.
I gotta let Senator Kitchen know. Frequently used as one of his songs as a half a loaf is better than none at all, or something like that. She would cite that when we were doing a bill, doing the appropriations and arguing over how much somebody should get. All right, Judge Zone, you want to introduce us to Judge Jerome? All right, and I hope I pronounced his name right, so I should have let you just do it.
Let me make sure. I think I saw Judge Gyron come on. There he is.
Gyron, yes. Okay.
So good morning again, Tom Zone, Chief Superior Judge. And this morning, I have the pleasure of introducing one of our newest Superior Court judges who was sworn in on January 3rd, and that is Justin Gyron. Justin, Judge Gyron, is a graduate of the University of Vermont. He went to Albany Law School, where he graduated cum laude and also worked on the law review. After law school, he was a law clerk, went into private practice, and in 2003, he became a deputy state's attorney with the Chittenden County State's Attorney's Office. He stayed in that position until the time of his appointment, and in 2016, he was designated to be the chief deputy state's attorney. There is no question that Judge Gyron is held in high regard by his former colleagues and the members of the bar. And at his swearing in, there was a number of comments made about him. And some of the words that were used were intelligent, respectful, and thoughtful. It was also commented that he was calm and unflappable. And I think it was State's Attorney Sarah George who commented that no matter how people were getting upset, he just had this very nice, calm demeanor. And I thought to myself at the time, well, that's good. He's going to need that as a judge. And then we also found out something about Judge Gyron that I think put it into even a better context. He has his private pilot's license. And so I thought, well, it's good that a judge is calm and unflappable. And it's really good that someone who is controlling you in an airplane is also calm and unflappable. And I think as we go forward, you will see that the characteristics that were identified as making him an ideal candidate for his appointment will make him an ideal judge as he goes forward in his career. And so I'm proud to present Judge Gyron.
Thank you, Judge Jose.
Thank you, Judge. I'm Dick Sears from Bennington County. And I'll let the other members of the committee introduce themselves, starting with Senator Baruth.
I'm Phil Baruth, representing Chittenden County.
I'm Alice Nitka, representing Windsor County.
I'm Jeanette White, representing Windham County. Hello again.
Well,
Good morning, Judge Gyron. Calm and unflappable. Do I understand correctly that you're coming to Caledonia County?
you do understand that, Senator Benning.
That is a quality that I will very much appreciate. I'm Joe Benning. I'm from Caledonia County, and I've been a trial attorney here for 38 years.
I think he's suggesting that other judges who've been in Caledonia are not as common and laughable. Judge.
I did not say that, Senator Sears.
Oh, okay. I just wanted to make it clear. Get clarity on that. And tell us a little bit about your interest in becoming a judge and why you chose to apply for the position.
Certainly. Thank you, Senator Sears. And good morning to everybody, and thank you for making this time available for me to meet with you. It's interesting because, I've been asked the question before, why did I, what made me interested in being a judge and join the judiciary? And it's hard to come up with there's really no short, easy answer, except that when I first became interested in being a lawyer, I was really interested in being a prosecutor early on, after some interest in being a police officer. And pretty quickly after becoming a prosecutor, as much as I enjoyed the idea of being in court and trying to achieve justice and upholding the law, as years went by, more and more I became more interested in the process itself and the way the legal system worked. And it became clear to me that what I really, one of the things that became very important to me was that the process and the system was fair, and that it was fair to everybody. And as I sat in front of a lot of judges and appeared in front of a lot of judges over the years, I began to think, I could see how they did their job, and I appreciated the challenges they had. And over time, I just began to think that I would really enjoy that position. I think that I would be well suited to it. I would enjoy being able to be someone that's, in a sense, protecting the system and making it available and fair to other people, to litigants. So that's sort of a long way of saying it's been an evolution over the years for me. And but that's really the reason. I think that the courts are one of the most important institutions we have as a society and in this country and state. And if I can be someone that can serve in that capacity, and I think that I can be and will be, then it was important that I put in the application and put myself forward.
Thank you. You were a Chittenden County Deputy State's Attorney for a while. And that county has made certain decisions regarding prosecutions. And as a judge, how do you look at those decisions? I'm trying to be, for example, not prosecuting certain crimes. And if you're in Caledonia County, where the prosecutor there may prosecute some of those crimes, how's that going to affect your ability to on the bench?
Well, certainly my experience in Chittenden is going to probably inform the way I approach cases going forward. But really, in my mind, the legislature has enacted the laws, they're in place. And if one state's attorney chooses to enforce certain laws, either chooses not to enforce ones or chooses to enforce them in a different way and seek different types of resolutions, however they want to approach the cases, it's going to be my responsibility to look at the laws that are in place. And so a case that might not be brought in Chittenden County may be brought in Caledonia County, but that's the that's the province of that state's attorney. And I certainly respect that, and I'll approach that case as I would any other case. In other words, I wouldn't discount it just because it's something that may not have been brought in Chittenden County or may have been prosecuted differently in Chittenden County for that matter.
It raises an issue that this committee has been confronted with many times, and that's geographical justice, where, and we've seen it actually in the courts as well as prosecutors, defense bar, etc., of how different crimes are dealt with differently. We've been talking about a bill on this, lack of a better term, shoplifting, but in large amounts where the aggregate value is very high, and the people that certain stores are uncomfortable with what's been going on, obviously, and concerned about the aggregate value of those. So I think that's one of the things that this committee and the House Committee on Judiciary have been long trying to deal with, is this kind of geographic justice where somebody in Chittenden County commits a crime and that crime is either not even prosecuted or diverted, and somebody in, I'll use the example of Caledonia County, is prosecuted and ends up going before the judge. Either there's a plea agreement or ends up in trial. That's really the reason for my question. Other questions for Judge Drew? Am I the only one with questions here?
I'll just throw in a comment, Judge, that we will welcome you to Caledonia County.
Thank you, Senator. I am really looking forward to it. I had a chance to get up to Caledonia County last week or the week before. Most of our orientation has been remote, and really enjoyed meeting the staff and getting a chance to see the courthouse. And I'm very excited to be up there.
Are you going to be co-assigned in Essex County as well?
Yes, I'll be covering that as well.
That's one of the last best kept secret in the court system. The clerk usually asks you what you like in your coffee when you come in the door.
That sounds like a welcoming place.
Any other questions?
I just have a thought.
Yeah.
In doing judicial retention, one of the issues that regularly comes up is that that judges lose a lot of their friendships and contacts that they've had before because they're in such a different position. And I don't know if you're prepared for not having your friends or being able to hang out, so to speak, with people that you did before. And I know that's been, judges have mentioned that. I don't know if you're thinking about that.
Yes, thank you, Senator. I've thought about that. I've applied, more than once, and so during that process, I've heard the same sort of information from other either sitting judges or people who have made the same transition, and so I've kind of prepared myself in advance. But even as a prosecutor, you do have a set of friends and social contacts that are somewhat personal and unrelated to those you have as a lawyer. At the same time, I do have friends who have become judges, and we were able to still maintain those friendships because they would often be in different counties. And so there wouldn't be a conflict. And even if to the extent there would be a conflict, we always kept our, conversations separate from our jobs. So I anticipate that there'll be some isolation, but I think I'm prepared for that. And at the same time, I will still try to maintain those friendships, but on a purely social level. And I think that that'll be manageable. I hope it will be.
Okay.
Best to you.
Thank you.
Any other questions? Senator White, you probably saw the judge in the nominating board.
Right, and asked plenty of questions then. So I will just say good luck in Caledonia County.
Thank you, Senator.
I guess
And Essex.
Particularly Essex. The court reopening is actually a difficult, it's a subject, and that I have a meeting on Monday with Justice Eaton and some others to see if there's something we can do in the Budget Adjustment Act to help with reopening. But as a former prosecutor and now a judge and stepping into a new county and being trained remotely, are the things what kind of things struck you as really needed in order to get back to some form of normalcy?
Well, certainly the ability to be in person in some cases is, you can't really discount it, particularly criminal cases. I think it's difficult for defendants who are not able to speak with their attorneys in person when they're doing arraignments and the process is first starting. So whatever we can do to get back in person, or at least have the option to be in person, I think is vital. And in terms of what's needed, logistically, that's a little hard for me to say. I know that there's been talk about increasing the availability of masks so that, we can be a little more protected while we're in the courthouse. But generally, I'd say whatever we can do to, let people back in the courthouse would be great. I do appreciate that, we've been able to do a great deal of work remotely the last, almost 2 years now. And I think it's made it, that availability, I think, can be used even past the pandemic in the future. But that's if people are comfortable, appearing remotely. But I think a lot of folks really want to be in person, and if we can make that happen, I think that'll be the best for all of us.
Great. All right. I don't have any other questions. I think you've answered them fine. And Judge Zone, thank you very much for
Thank you.
introducing us. And we're going to